I call Tim McIndoe.
I move that the question be now put.
Call Jacinda Ardern.
Thank you, Mr Chair. I'm really pleased you've given me the opportunity to speak on part 4 because I have a very specific issue that I would like to raise with the Minister and would really appreciate some feedback on this important issue because it's been raised by the Law Society and as yet I haven't heard it debated in this House. Now, Mr Chair, it relates, as my colleague Annelise Galloway mentioned, more broadly speaking, part 4 relates to enforcement provisions. And as set out in part 4, clause 180A, it states proceedings involving classified security information. Schedule 2A contains provisions that apply in civil and criminal proceedings that involved classified security information. So that takes us directly to Schedule 2A, and that's what I would like to speak to in my contribution. Schedule 2A relates to provisions relating to classified security information. And I think it's important to point out that this schedule, as I understand and as pointed out by the Law Society, was not present in the bill. It's contained in Supplementary Order Paper number 108, which is obviously substantive, at the time that the bill was introduced to the House. Now, by virtue of that, that means, as I understand, it would not have been subjected to any Bill of Rights vet, as a bill upon introduction usually is subjected to. And so that means we haven't had full consideration as to the broad sweeping nature of this schedule. Certainly that's the point that the Law Society has made. So it hasn't been the subject of a BORA. Now, officials, as I understand, have had this issue raised with them directly by the Law Society, and the response that government advisors gave back to them was that it was their view that these provisions were narrow. Now, I want to test that view with the House. It states in Schedule 2A, application of this schedule states this schedule applies to any criminal or civil proceedings, including public law and judicial review proceedings, that relate to the administration or enforcement of this Act. If A, all parties to the proceedings have access to classified security information that is to be produced or referred to in the proceedings, or B, the defendant in proceedings intends to produce or refer to classified security information. So what classified security information is and how it is defined is very important for the purposes of this Act. Now, according to the Law Society, their view is that the definition is very wide. The definition states in Clause 3, meaning of classified security information. In this schedule, classified security information means information that is relevant to proceedings that relate to the administration or enforcement of the Act, and A, is held by a specified agency, and I believe that with specified agency we're talking security, intelligence or law enforcement, New Zealand Defence Force, the GCSB, New Zealand Police, or the New Zealand Security Intelligence Service. That the head of the specified agency certifies in writing that it cannot be disclosed except to the extent provided in Clause 4, because in the opinion of the head of the specified agency, the information is of a kind specified in subclause 2, and disclosure of that information would be disclosure of a kind specified in subclause 3. And then when you go on to those, they basically say, if this information, it's very hard to explain schedules, basically what's considered classified secure information is basically determined by the agencies who hold that information. They basically have the power to write to the court and say, we don't believe this information should be disclosed because we determine that it fits the criteria of this bill. That it might lead to the identification of a source of information. It might, if disclosed, give away the functions of security or intelligence. It might prejudice the security or defence of New Zealand or international relations. It might prejudice the entrusting of information to the government of New Zealand on the basis of confidence. It might prejudice the maintenance of the law. Now, in writing, that all sounds fairly robust. But if you're actually allowing those agencies to determine that for themselves, then that potentially becomes problematic. As the Law Society has pointed out, they've advised the Minister specifically, Mr Chair,
I call Lewis a wall.
Oh,